Meeting is called to order. Will the clerk read the roll call?
Commissioner McBride, Commissioner C.
Here.
And Chair Johnston.
Here. Agenda review. Linda?
Yes, good morning, Chair and Commissioner C. We have two items for you. Item 12 is the materials scheduled in your agenda book to be presented this morning to you, so you should have copies of item 12. And item 10, we have a letter submitted by the District Attorney's Office at the Board of Supervisors meeting on April 19th. That is for item 10.
Okay. I'm not sure Okay. Are there any other comments regarding the agenda review? Okay. If not, we will proceed. Approval of minutes for July 16th.
I've read them. It's been a while, but I didn't see anything obviously required.
Okay. If there's no objection, the minutes stand approved. Commission members and staff comments. Other than good to see you, Mr. C. Sorry, I delayed the meeting's opening. Okay. Let's move on. Let's see. Special meeting agenda. Recommendation to approve stipulated decision and order regarding report of alleged violation, case number RP 100002, Carpenter.
Good morning, Mr. Chairman, Commissioner. I'm Craig Steele, the outside investigator on this matter. This is a relatively simple case of two exceedance of the county's contribution limit, each by $100. Each contribution exceeded the limit by $100. This was in connection with the 2010 election. The committee admitted to these violations and asserted that they were in error, and the contributions in that amount should not have been accepted. The committee has agreed to enter into the stipulated decision and order that is before you, which is a stipulation to pay a fine of $200 per violation, which is twice the amount that was improperly accepted. They have supplied a cashier's check, which is a copy of which is in your packet. In my view, it's a first violation. It appears to be an inadvertent and a relatively minor error, and therefore warrants a mitigated penalty in this case. And so I recommend that you adopt the order that's in your packet.
I don't know when there's only two of us if I can second that, but okay. Then I second that. Is there any discussion? If not, so ordered. Thank you.
Thank you.
Okay, our next item, recommendation to dismiss complaint P10003, Strickland versus Coalition for Responsible Government. Item number 7.
Mr. Chairman, Commissioner, case number P10003 involves two independent expenditures that were made in connection with the 2010 election. Both independent expenditures were made in May of 2010. They were made by independent campaign committees that were in opposition to the complainant's candidacy for the Board of Supervisors. One of the committees that made the independent expenditure is connected with a statewide labor organization, and they were the committee that had the filing responsibility in this matter. The county's ordinance requires, in the event of an independent expenditure, that certain filings be made within 24 hours of the independent expenditure being made. Those requirements are above and beyond the filing requirements of state law and the Political Reform Act. Essentially, the county requires additional information to be filed a little bit faster than what state law requires. The Political Reform Act also includes a provision that says that cities and counties may impose additional requirements, except that in the case of committees that are formed to function outside one jurisdiction or statewide or in multiple counties or multiple jurisdictions, the filing requirements that are imposed by cities and counties do not apply to those committees. So in other words, your county's filing requirements apply only to committees that are formed to function solely within Ventura County. In this case, I have reviewed the documentation that indicates that the respondent is in fact a state general purpose committee. They have activities not only in Ventura County but also in Riverside County. And in that instance, the Fair Political Practices Commission has advised twice, including once here in Ventura County, that that section of the Ventura County ordinance is preempted as applied to state general purpose committees. Given that this is the respondent in this case is a state general purpose committee, I therefore recommend that the matter be dismissed because that filing requirement does not apply to this committee. I should note that as to the state law requirements for filing, this committee fully complied and timely complied with the state law requirements, state law filing requirements with respect to this independent expenditure. So it wasn't like it was hidden or not disclosed. It just wasn't disclosed in the manner that the county ordinance would require.
Okay, what is the pleasure of the commission?
I had one question, perhaps, to council. With respect to the statewide committee requirements, you're satisfied that this is a statewide special committee?
It is definitely a statewide statewide general purpose committee.
The only question I had was the requirement that 50% of their donations be used in connection with their activities. Do you recall that?
I'm sorry, I don't know which requirement we're talking about.
Let's see, we have the amended right here. It was the definition of statewide special statewide committee. Well, I'm not finding it. If you're satisfied that it's a statewide committee?
It is a statewide committee with activities in counties other than Ventura, and it actually predated its activities in Ventura County. It was active long before this election, so it is a state general purpose committee.
I just didn't understand. There were two options. One, you're a state political party, or two, you spend 50% of your donations on those related activities.
Yes, it is not a controlled committee, which is the 50% requirement. It is a general purpose committee, which means it can be active in elections all over the state of California at any level. And so, for example, in Riverside County, they were active in local and state elections. Ventura County only in the county elections. So they were active in different types of races in different parts of the state.
Well, with that, I concur that the matter is preempted by state law, and therefore I would move the recommended action.
Okay, I'll second that. Without objection, that'll be the order. I did have one question regarding the subject of statewide. Is there a criteria that is in place that describes what one must do to be a bona fide statewide committee, as opposed to someone deciding that they will create a statewide committee to circumvent the local rule?
There are FPPC regulations which define the state general purpose committee. I do think, as I noted in my report to you, there may be ways to tighten the ordinance, that particular section of the ordinance, to take care of this problem in future elections. There are policy implications that the board obviously would have to look at in doing so, but it is a possibility to eliminate this, I don't want to call it a loophole, but this particular preemption issue for future elections if the board was so inclined.
Okay, thank you. Okay, so item number 7 has been dealt with. Let's go to item number 8.
Chair Johnson, could I just make one comment on that? Last April, the board did amend section 1270 of the ordinance to put in a reference to statewide general purpose committees, saying this section shall not apply to an independent expenditure committee during any period of time that it qualifies as a state general purpose committee pursuant to section 82027.5 of the Political Reform Act, as supplemented by section 18247.5 of Title II of the California Code of Regulations and Successor Laws to deal with just this issue. They have before them, as we'll talk about later, an amendment to the ordinance that in that section makes it even more general, to not limit it to that one regulation, because there was a movement at the FPPC to amend that regulation and split it into a few regulations, so that rather than have been relying on a specific regulation number, it just says, and regulations of the FPPC. But this case predates the amendment of that ordinance, so the ordinance in effect at the time of that aspect of the complaint did not have that exclusion. So I think the board has effectively dealt with it.
Okay, thank you. Item number 8, adopt the proposed decision and order regarding a report of alleged violation. What are these alternatives here? Mr.
Chairman, Commissioner, thank you. This matter involves an admitted technical violation of the reporting requirements of the ordinance by the Committee Vote for Parks 2010 supervisor. The committee at different times accepted 2 contributions within the contribution limits from 2 spouses. They were both reported on 2 different reports as being from the same spouse. However, the ordinance does allow for spouses to make individual contributions, and they were in fact contributions from 2 different spouses. This matter was referred by the Elections Division prior to contact by the investigator. The committee admitted the violation and self-amended the form without any contact from me or requirement to do so from me. And so in that situation, it seems to me that on a first violation and what is really a technical just reporting violation, no particular fine is warranted, and in fact a fine might be a disincentive to committees that self-report and self-amend in sort of minor technical issues like this one. So I am recommending that the committee find that a violation occurred and send the attached warning letter signed by the chair, so there will be a record of a violation in case there are future problems with this committee or this treasurer. You will have a record of enforcement action and having addressed the violation of the ordinance, but I do not believe that it rises to the level of imposing a fine, and I'm not recommending a fine in this case.
Discussion?
A couple of observations, perhaps. This reminds me of a matter that we had early in the committee's history where the fine was lower than the commission thought it should be because of the costs associated with handling it. In this case, there is no suggested fine. I had a couple of observations. One is, yes, it's perfectly accurate that husband and wife may make separate contributions, and I don't have any quarrel with that. And in the end, that's exactly what happened. It's not clear to me that that was the intent of the parties at the time that the contributions were made. The fact that they were retroactively changed to satisfy that requirement is a factor. The other thing is that the self-reporting, I think, is a little misleading, and that the complaint was filed on April 1st. It wasn't until May 17th, a month and a half later, that the committee made the appropriate changes and corrected the matter. I think that it probably would be counterproductive to not follow the recommended action, in that it would cost more to take further proceedings in connection with this matter than it's worth. But I would think that it might not be inappropriate, even in cases where there is no specific intent to violate the law, to impose a fine that at least reflects the fact that once you engage the machinery of the investigative process and so forth, there ought to be some consequence if, in fact, the law was broken. So I probably would have imposed a fine. I guess I disagree with counsel's characterization that it would discourage people from self-reporting. Once the complaint's been filed, anybody can look at it, and I don't see how having to pay a ministerial fine for having done something wrong is going to discourage people from self-reporting. With those comments, I have nothing.
I guess I'm not sure how the minds of campaign committees would work, but I guess when I first read Mr. Steele's report, I thought that it is possible for these kinds of things to happen, particularly when these are so kind of infrequently applied rules, and that the charging of a fine for correcting something, I guess in my mind, would be somewhat, they'd say, well, why bother self-correcting? Let's see if they catch us or see if they put any penalty on us, and then that would trigger, we'd have to go through the mechanics of the whole process, which in the end most likely would exceed the value. So I guess I'm comfortable with the recommendation, and if there's no objection, that is the order of the commission. Okay. Thank you.
Thank you, Mr. Chairman, and the letter will be prepared for your signature to send out.
Okay, item number 9. I receive and file an oral report updating on the status of a complaint number P10001, Fonte versus Strickland, and provide direction to staff.
Thank you, Mr. Chairman. Commissioners, this is a complaint that has put me in sort of an awkward position based on our structure, because I believe, and I think Mr. Oriano would agree, that I am not acting as the Commission's attorney, and I don't have any role in giving you legal advice, certainly, and no role in giving you confidential legal advice. This particular complaint is a compilation of a couple of different violations that are alleged. One is an allegation of basically an intra-candidate transfer of funds from one campaign account to another campaign account, funds in a fairly significant amount of money, as well as some other allegations of excess contributions. The intake attorney that made the first review of the case found that there was probable cause and referred it out for investigation. At that point, the respondent's attorney wrote a letter to the county with making some legal arguments, and he and I had further communications at the very beginning of this case regarding the constitutional validity of a portion of the county's ordinance that applied to the intra-committee transfers that occurred here. And council believes that based on a Ninth Circuit case fairly recently, that portion of the ordinance is invalid. I don't view it as my role as advising the commission as to whether the ordinance is constitutionally valid or not. In a case where, as we had earlier on the agenda, there's a clear preemption based on a statute, I believe it's my role to come in and tell you that a violation of the ordinance did not occur because the ordinance did not apply to that particular committee. In this case, I would feel more comfortable if the commission and the county had some legal evaluation of the ordinance, of the arguments that are raised by the respondent's attorney regarding the constitutionality of the the transfer ban. I hesitated initially in pursuing the investigation because the respondent indicated that if I did pursue the investigation on that particular issue, they would seek a injunction and sue the county over the validity of the ordinance. And so I decided to wait at this point to get some direction from the commission and for the commission to seek advice from counsel. And Mr. Oriano and I discussed this earlier in the morning. I can proceed with the investigation of that issue. The other issue is basically done. There's no real question about that violation, but it's all wrapped up into one complaint. I can proceed with the investigation. I do believe that it may well lead to litigation against the county, and did not want to take that action without consulting with the commission and with county counsel. So I seek sort of the guidance of the commission. I don't believe that I have the authority to split up the complaint when it's all in one single complaint. I don't know that I can tell you we can dismiss one and not the other. So that's why I'm here seeking some guidance from the commission. I believe you got a copy in your packet of the at least one of the letters that's been received from the Respondents' Council raising those issues.
We do.
So I seek the direction of the commission. Happy to push forward with the entire matter, recognizing that there may be litigation arising out of that. There may not be, but the threat has been made, and that's why I'm seeking the guidance of the commission.
And the threat was from which party?
Respondent.
The respondent?
Yes.
Okay. So if you pursue the investigation, they will sue. If you don't pursue it, is there any threat that we're not complying or enforcing the ordinance?
I don't know. The complainant hasn't. The complainant has responded, and the complainant's position is the ordinance is the ordinance, and if it was violated, it should be prosecuted, which is a perfectly reasonable position to take. And he would obviously like to have the full complaint investigated and prosecuted.
And did I understand correctly that the amount of money that was transferred, that the respondent said they'd hold that in abeyance and not use it pending the outcome? Did that end up being the case, or do we know that until we investigate?
We know that was what they said prior to the election. I intentionally did not communicate with them until after the election to not be accused of interfering with the election. Prior to the election, they said that they were holding the approximately $8,000 or $9,000 and not expending it.
Okay.
$8,700. Well, perhaps we ought to hear from counsel about what his conclusions with respect to the issue is.
Well, I wasn't aware, because it was an oral report of this issue being what was preventing this from going forward, but I guess my views are twofold. I haven't looked into the Ninth Circuit case, so I'm not prepared to issue an opinion that part of the ordinance is or isn't unconstitutional, especially in light of the review attorney's comment at page 2 and footnote 1 of his report, where he points out the difference between this case and the Ninth Circuit case, in that here we have a limit on the amount of money that can be transferred. So we have a slightly different animal that would be before the court. But aside from that, I don't think it's your commission's responsibility to decide whether any aspect of the Board of Supervisors and the county's ordinance is or is not invalid, and that you should go forward on that, the basis that it is valid, and if a court should say it's not, or if the board should repeal a part, or settle a lawsuit, that's the decision for the county and the county's Board of Supervisors. However, under Section 1296 of our ordinance, the investigating attorney does have the authority to settle complaints, and this could be part of a settlement. Your direction could be for the investigating attorney to work out a settlement that satisfies your board's concerns about the overall complaint, the amount of the fine that's appropriate, while just having that issue part of the settlement and not adjudicated. There's no reason why you have to have every aspect of a complaint adjudicated if there's a fair resolution of the overall complaint. But that's solely in your discretion. In other words, the investigating attorney could have come forward to you with a settlement today and said one of the sticking points in the settlement was this issue, but in light of the suggested fine and the rest of the settlement, it's not worth having a lawsuit over an issue when we get this kind of resolution of the overall complaint.
Well, I'm assuming the council could probably reach an agreement with respect to the contributions in excess of $700 with regard to the business and the business owner. In that regard, I thought it was interesting that there was no claim that she wasn't the owner or sole owner of the business, but be that as it may. The other issue the council alluded to was the amount of the contribution. I don't know anything about the last in, first out method of allocating contributions when they are dumped into a campaign in a lump sum. It's clear that at least initially it was a lump sum not attributed to 13 contributors within the campaign limits. I guess I need some help or guidance with respect to the issue of whether that accounting methodology is appropriate as claimed by the committee.
That accounting methodology is a standard method that's followed by the FPPC, the LA City Ethics Commission, and others. To my knowledge, we haven't had the occasion to look at an issue like this with regard to your ordinance. Were I going through their accounting, I would have used that method, and would use that method to determine whether that contention in council's letter is correct, because it's really the most realistic approach to trying to figure out who gave what when you're talking about one of those sort of lump sum transfers. As a bank transaction, it's a lump sum transfer. As a reported campaign contribution, it's something different, and that's the only way that really makes sense to determine how those contributions were attributed. So I would have used that method, and I would use that method if you direct me to look at the issue.
So if we're correct that intra-campaign transfers are protected and the accounting method is an appropriate one to have used, then the conclusion would be no harm, no foul.
That's correct.
With regard to the annotation of the individual donors or lack thereof, the 30 instances in which the donor status was not enumerated, did we ever hear anything from the county's IT people about whether the explanation that it was the county's programming that caused the error, or confirmed that the data probably was or was not in the electronic filing?
I have not, and I have not yet explored that question.
It just seemed to me that there was a difference between respondents' conclusion that as long as the written document that was ultimately filed is the official record of the characterization of the donors and so forth, there still is the question of whether or not the electronic filing has to be accurate as well. And I guess I would be interested in knowing from our IT people, the county's IT people, whether that was the probable result.
And I can certainly explore that as part of this if directed to take that issue forward.
Well, on a more general level, rather than the detail of this case, I guess my observation is that this whole thing of trying to come up with some sort of fair due process without stepping all over freedom of speech and elections and all that sort of thing, which is always debated, plus the cost of enforcement, that we're sort of still and will continue to be in a little bit of research and development, trying to figure out how to tailor this in a way in which we don't step on the state's laws, but also don't leave opportunities for people to circumvent the purpose of the local law. Certainly being able to transfer large sums of money from some other campaign is one of the things that I assume that the board was interested in preventing. I would think the community would have the same interest in that. Normally that is an incumbent's advantage and discourages challenges when you can have that kind of potential war chest. So it's an important issue, but at the same time, I guess we should be mindful or try to find the least expensive way of getting to our goal, which is to improve the ordinance and to be sure that there aren't scofflaws out there. So what am I hearing, Robert, that possibly to proceed with a settlement would be one way to keep our part of it going, but at the same time, maybe the board should be looking at this. If there is a constitutional question, it seems like it's a lot cheaper to deal with it in a legislative form ahead of time than to go through the whole legal proceedings and have the courts tell you that it's wrong, and then you get to start trying to make your corrections.
I think how it proceeds from here is in your discretion, and whether you want a report back from the investigating attorney as to a potential settlement and to wait at that time would be appropriate. It's going to lengthen the process, which is already a year long as it is. I don't think I'm even in a position to tell you whether the board would want an opinion on that section of the ordinance. They're aware of the issue. There is, I think, a suggested change in the ordinance that we're going to talk about in a few minutes as to transfers for county offices. And they did look at that issue. At least a couple members have looked at that issue in proposing the changes. If the board did want an opinion on that issue, of course our office would be the one to issue it. I don't know if it would even be assigned to me. County Counsel Smith may decide it's appropriate to have someone other than me issue that opinion. Matt Smith may, for example, be given that task. But that is going to be a long process that I think is a diversion from the issue of whether you enforce the current ordinance or not, which is, I think, your responsibility and your investigating attorney's responsibility. No court has declared that section invalid. The board has not repealed it. It currently applies, and if it is a literal violation of that ordinance, I think there are only the two options I outlined: a settlement that is satisfactory to your commission of the overall complaint, or going forward with what is at least a facial violation of the ordinance.
Okay. Question of staff is, I don't know if this is appropriate or not. That's great to ask, to say that before you're about to say something publicly that may be inappropriate. But since this has been going on for a year, is there any indication or discussion about whether or not the legislation maybe needs to be modified, or is everybody pretty comfortable that, like many issues, there's more than one opinion as to the validity, and we just proceed to enforce it?
Well, from my opinion at this time, on item 10 is addressing the proposed ordinance brought forth by the Board of Supervisors, and I believe Council Oriana will speak to that behalf. And yes, this case has been ongoing for 1 year, so we're also waiting for your directions to move forward.
Okay.
I guess I agree with you that perhaps the direction to explore settlement is the next appropriate step, and to take further action if need be thereafter.
Okay. If that's a motion, I'll second it.
Okay.
Okay.
And I will-
No objection.
And I will move that forward as quickly as possible now, having done.
Thank you very much.
Thank you.
Okay. Item number 10, receive and file red line of the proposed amendments to the Ventura Campaign Finance Reform Ordinance being considered by Ventura Board of Supervisors. You have a motion for that?
So moved.
Okay, seconded. So ordered. Okay, now, we're getting close to modified agenda. Now, we got one more here, 11. Receive and file, no, did we just do that? No, we have two
No.
receive and files. Okay, receive and file the Ventura County Campaign Finance Ethics Commission report prepared by staff for the period of January 1 through December 31st. Do I have a motion?
I've looked at the report and move its approval.
Okay, I second it, and without objection, so ordered. That brings us to number 12.
Yes. Before you is the report on the administrative cost in administering the campaign reform ordinance. As per Section 1297L, the Commission shall meet at least once a year to review the administrative and the financial efficiency of administering this ordinance. So staff has prepared for you a cost summary outlining the cost for fiscal year 2009-2010, as well as the first 3 quarters of fiscal year 2010-2011. The itemized list details County Council's costs, Ventura County Elections Division, the County Executive Office, and the Commission's attorney.
Any discussion, Frank?
Just to receive and file?
Mm-hmm.
Yeah. So moved.
Okay, seconded, so ordered. That brings us, what, to public comment?
We have no public comments.
Okay, there being no public comment, I think our job is done.
All right.
Being no objection, the meeting stands adjourned.
It's awkward just having 2 people.